Well, hello, everyone. I'm going to now start our seminar on AI ethics and law. This is an initiative by the Logarithm and sponsored by DAS Advogados. And I would like to thank you very much. Thank all the speakers of this event for joining this seminar, and also thank all the audience for joining the discussion today. Our concern here and our main focus in this seminar will be on the logical representation of ethical and legal reasoning, mainly on the application of knowledge representation for legal reasoning and ethical reasoning, which is one of the main tenets on this field called computable law, that's trying to make ethical reasoning and legal reasoning computable, so that we would be able to build intelligent legal agents and intelligent ethical agents. And what means that artificial intelligence tools could also be able to reason about ethical and legal issues to comply with the law and comply with ethical principles and standards. Since artificial intelligence models are adaptive, it's not sufficient to pre-establish commands for the compliance with the law or ethical reasoning in particular context. So this reasoning must be made if we want to have ethical and legal agents that can reason and adapt to context to comply with ethical and legal standards. So within this effort, we have made a call for abstracts, and we received many contributions, and selected some researches which are relevant for this field. And we are happy that we have had contributions from different countries. We have contributions from Germany, Luxembourg, Poland, Venezuela, and also Brazil, and Italy too. So I'm very happy that we got a very interesting group with several interesting subjects, and I'm sure we will have a nice morning for us Brazilians, afternoon for Europeans. But and I'm sure we will have a very rich and nice discussion. I would like to give the floor a few minutes to Danilo Aragão, who is our sponsor, and I would like to thank you very much for the support for this event. You are on mute, Danilo.
Thank you very much, Professor. As I told you, I'm a big fan of yours, as you are developing in Brazil the main standards for artificial intelligence and logical reasoning in the Congress. The AS Advogados decided to sponsor this event, and as we are establishing and studying lots of discussions on artificial intelligence, on mass contentious discussions for banks and other companies, it's very important to develop from now on the main standards on ethics and logical reasoning for artificial intelligence. That's it's a brief speech. I'm very happy to be with you guys right here. I think the discussions will be very insightful. I'm very happy to be right here. Thank you for everything.
Thank you very much, Danilo. And so now I would like to start our presentations and give room for the speakers. We would have 15 minutes for each presentation, from 15 to 20 minutes, so that we can we have room for discussions, except for the keynote speaker, who is Christoph Benzmüller and David Fürmayor, who will have more time for the presentation. It will be 45 minutes, so we may leave 10 minutes for discussion within this time. So to begin, I would like to give the room to Galileo Sartor. Galileo is going to present a paper and his present research on logical English for computable law and ethics. Galileo Sartor is researcher at Siegfried Bologna, University of Bologna, and University of Torino. And this paper and this research is conducted together with Robert Kowalski, who doesn't need any presentation. Robert Kowalski is one of the main figures in the field of not only of computable methods for reasoning in law, but also for the representation of human reasoning in general in artificial intelligence. And it's a great honor to have him with us in this seminar. And Jacinto Dávila from the University of Andes, Venezuela. Please, Galileo, the floor is yours.
Okay. Thank you, Juliano. Let me share the screen. Okay. Okay, can everybody see my screen?
Yes.
Perfect. So as Juliano said, I'm going to present the work that is going on in developing logical English. So I will describe what logical English is and why we are working on it, why we're developing it. First, I'd like to briefly say what the motives are. We need a system for representing computable law. So for designing rules that are that can be interpreted and understood by a computer and that can be evaluated and whose effects can be evaluated by automated systems. This has been done in other projects that we've worked on and many more. But we're trying to make a step forward in addressing the human in addressing the interaction, the human-machine interaction. So first of all, legal rules are have a specific set of requirements to be able to have computable models. They need to be written in a more strict, a more precise way than what is normally than what can normally be the case. So the process of transforming rules, legal rules in computable form, is generally a translation of logical connectives and so identifying the minimum propositions and link them by their logical connectives, replacing vague or unnecessary terms or pronouns or repetitions, and using exceptions and defeasible rules. And another important thing is being able to provide the user with a detailed trace, a detailed explanation of the solution that is presented. So the automated system should not only give an answer, but it should also be able to reason about how it reached that conclusion. So the idea of logical English is to have a general purpose computer language, which is also a controlled natural language, so controlled form of English, with the main goal to be, where the main goal is to be easily readable without technical training in logic or computing, as well as being easier to write for non-technical users, and explainable by default. The underlying system of on which logical English is built is Prolog. So we can have the power of Prolog in a more human readable and human friendly form. The main the natural language, this controlled form of natural language, is defined by the user when the rules are being written in the system, are being added in the system, by defining templates, so models of the sentences that will be used in the knowledge base. For example, here we can see that a person is charged with a crime in a proceeding. Is a template, is a mock sentence where a person and a proceeding are variables which can be defined according to the specifics of the case that the user wants to analyze. An important goal of this representation is to deal with vagueness and ambiguity, so with concepts that are not defined in the legal text or that are unclear in their applicability. This is important because often judges may argue against a decision depending on certain definitions or certain clarifications that are not present in the original legal norm, but are available in case law or that come from other legal documents. So the legal corpus can often be very complex to especially to non-experts, but not only. So there's a certain degree of ambiguity often present. This ambiguity can be voluntary or not. So this too has to be modeled in the logic representation, and if we have a logic representation that is functional in that it can explain these inconsistencies in the law and automate certain portions of law, then we also have a way of verifying that the law states what is intended. So a brief example of one area in which there is an issue of definition is the notion of suspect. This is something that we analyzed in the cross-justice project, the project that we worked on in Bologna. So we have different definitions of accused and suspects. Normally, European law defines accused as persons being charged with a crime, although Polish law states that a suspect is a person that was presented charges or was informed about the charge. This inconsistency is not easy to detect if one is not an expert of both European and Polish law. So if we can model these rules, these legal norms in a way that is easier to interpret and to read, then we're ready to identify these inconsistencies. So here we can see that what I showed before, that the norms can be modeled in logical English, where in red and blue, you can see the variables. You can see some of the variables that are present in these sentences. So in the first occurrence of a variable, it starts with an indefinite a or and, or an, sorry. And in the subsequent occurrences, there's a the. This enables the system to understand that those are the same variable. So we can see that the directive states that a person is accused according to EU law in a proceeding if the person is made aware that the person is charged with a crime, whereas in Polish law, a person is suspect according to Polish law if the person is made aware that the person is charged with a crime. So what logical English does is it takes these sentences and builds the prologue rule base, where it keeps a track of the variables, those that are grounded and those that are not, and rewrites the rules in pure prologue. Here we can see also in the second line that there is a meta predicate, so a predicate contained in the argument of as a variable of another predicate. This enables different reasoning models. Then the system can be posed some scenarios, so some sets of facts and queries. And according to these facts and queries, which are again translated in prologue, the system gives the relevant answer. So in this case, we are generally asking what is the status of our subject, Marco, according to EU law and Polish law. So we can see that there's a difference, there's an inconsistency. What we can also do is ask for a more detailed answer. So in this case, we can see that Marco is accused according to EU law, as proved by the knowledge base, because there's a fact that is used in evaluating this rule. So we can see the relevant facts that are necessary for a certain conclusion. This is another example on the Italian citizenship, which states that a person is an Italian citizen either depending on the citizenship of the parents, or if he's born in Italy from stateless or unknown parents. In this case, we can see, again, the prologue representation, but more importantly, we can see that with certain scenarios, we can have the answer being more detailed. So we have the fact that Giuseppe is an Italian citizen because Tatiana is his parent. And why is Tatiana the parent of Giuseppe? Because she is the mother of Giuseppe. And it is also the case that Tatiana is an Italian citizen. So we have the full sequence of facts and rules. So the system can explain its the reasoning behind the conclusion it reached. This is very important in modeling, in representing legal rules, because the judge that may be using the system as a support tool needs to know why a certain conclusion has been reached, and he needs to be able to read both the rules and the solution and understand understand what is written. So the necessity for technical training, technical knowledge, is not something that that every judge has, not necessarily. Also, the legal expert that is writing this relatively complex rule base may need an easier way of interacting with the system. a way that is also more isomorphic, so more closely tied to the original legal text. Going further, we can use the output of logical English and change the reasoning engine. So in this case, we are looking at using SCASP, which is a top-down interpreter for answer set programming. And SCASP has a certain number of advantages and some disadvantages related to what we're working on. But mainly, we can add support for reasoning with abduction and with constraints. So the user, so this is the explanation of SCASP. The user can also state that he does not know if his mother is an Italian citizen, as we can see in the example on the right. And in this case, the system will try and verify, try and see if there's if it can prove the opposite. If not, it will assume that fact to be true. This is just to show that we can change the engine, we can change the output, but we still have a system that is easier to interact with, and that can give an explanation with all the necessary references and all the necessary information, easily understandable by non-technical users. In the future, another thing that could be added is support for multiple languages, which to some extent we have implemented in logical English. But going further, it might be important. It would certainly be useful and important to have the user interact with the system in the language that he or she is more comfortable with. All this to make the system more user-friendly for everyone, for who is writing the rules, for those who are interacting with the system and need assistance in legal matters. That's all for me. Thank you.
Thank you very much, Galileo. We still have some time for a discussion and for questions. I'd like to know, Roberto, are there questions from the audience? Well, I have a question, Galileo. I'm one of the main challenges for computable law is related to the ambiguity and vagueness of legal language. In fact, this is one of the most challenging problems for the constructions of those precise clauses that may be computed. And as I understood, the way you have chosen to handle this problem is to introduce further definitions of the terms and of the variables that may avoid the ambiguity. Is that right?
So thank you for the question. The main thing that we've noticed in the research projects we worked on related to legal rule modeling is that the best way of providing clarifications and providing more precise definitions is to interact more with the experts of that specific domain or of that specific legal system. And often the open-ended, the open clause that are present in legal texts are left to national implementations or to judges to better define. So, for example, European directives often have this do not strictly define certain concepts, but they give a limited list of examples. The specific definition is left open-ended and can be enhanced by judges, by national legal experts. So if we can ease the process of writing and amending rules, we can verify, we can have more complete legal representations, and also we can use those legal representations to verify whether the effect of a certain law or of a certain amendment is the one that was desired.
Thank you, Galileo. There is a question from the audience, which is concerned on applications of this method. Of course, our discussion is much more abstract and theoretical, but the question from the audience relates to possible applications of this method. And the question is, how could logical English help the judge in this decision-making moment? Could be develop the tools that help judges in the decision-making moment, or and how could these logical English systems be connected with present applications of AI to law, using machine learning to classify resources, automate, to classify documents, and etc.
Okay, so I think that again, going back to the brief experience in previous projects, I think there is a lot of usefulness that can be had from a system built on logic programming and logical English even more. So, because if the judge may use a system like the one that an expert system built on top of logical English, for example, to find out precise legal references. So in complex cases, the tool could assist the judge in identifying which laws should be applied, which laws from different countries may have an influence on the case at hand. So where the details of the case go further out from the specific legal system that the judge or indeed the lawyer is more experienced in. So we're not building a tool that is meant to replace judges or lawyers, but to enhance their work by giving an assistance that is tied to the legal text.
Thank you, Galileo. Michał, I have a question for you.
Yes, thank you very much. Congratulations, Galileo. Great talk. It's great to see these subjects retaken, as logical layer is, of course, not the exclusive, but is very important layer of representation of legal knowledge and reasoning. My question would be whether you're considering using some theory of normative positions in your system. So such verbs like can, must, may have very different meanings in particular jurisdictions, and this has been well handled in legal theory from the times of Hochfeld through Kanger, Lindahl, and recently, of course, more recently, Marek Sergot and Giovanni Sartor, last but not least. So the question is whether you are considering imposing any type of this theory on your knowledge representation. Thank you.
Thank you. So I think that a certain level can be reached without adding too much complexity by, as I briefly mentioned, through the use of meta predicates, we can, for example, represent obligations or permissions. I think that in imposing a certain way of writing the rules may be a bit too much if we want the system to be generic enough that it can be easily used and that can represent legal knowledge and at the same time that can represent the complexities of legal knowledge and also be easy to interact with. So I think that a certain degree of what you said can be obtained without adding too much complexity. So by stating that for example, a person has the obligation to pay a fine. So that would be a way of modeling, like you said, the word must or an obligation in this case, without adding a specific layer only for these kinds of rules. But this is my opinion.
Okay, thank you, Galileo. Actually, João Oliveira from the audience has made a very similar question on whether you are considering applying not only to rules in natural language or also considering legal positions and legal relations, such as duty rights. So it's the same question by Michał. And Gabriel Rosa Carnaval has also has a question. He's asking how this representation model could be applied to the revision of legislation in a more practical way. What could be practical use for revision of present of legislation using this tool?
So if by revision we mean amendments or changes to a certain rule or a certain set of rules, then the system can be very useful because we can have a certain a set of examples of how this rule of the outcome of the rule that we intend. And if we modify the logical statements, so if we modify the rule, we can see if those still apply. So if I were to change parts of the Italian Citizenship Act, I could easily see if a person that should still be considered an Italian citizen indeed is considered as such by the system, or if the change that I made or the change that I proposed is has a different effect. So it might be that there are certain cases in which that the legislator didn't think about, where modifying a legal norm changes the intended outcome.
Okay. Thank you very much, Galileo. Would like also to congratulate you for the excellent presentation and for your present research. And now we may move for our second speaker. Monica Palmirani. It's a paper by Monica Palmirani and David Liga. Monica Palmirani is professor of computer science and law at the University of Bologna and coordinator of the PhD program in law, science, and technology. And David Liga is a PhD student at the University of Bologna, interested in argument mining, computational linguistics, and natural language processing. David is already with us, right?
Yes. Hello, everybody. I'm here.
Okay. So, David, the floor is yours. Thank you very much for joining this seminar.
Thank you to you. I share my screen. Okay. Can you see?
Yes.
Perfect. So I'm very happy to be here. So thank you. Yes, I'm David Liga. I'm a PhD student at the University of Bologna and at the University of Luxembourg. And today I will talk with you about argumentative sequence labeling and rule classification using transfer learning. So this is the layout of my presentation. I will start with an introduction about the motivation and the long-term goal of this kind of research. I will also spend some minutes to talk about the methodology that I used. And then I will move to the experiment. In particular, I will talk about two experiments. One is related to the detection of argumentative components, and this is where argumentative sequence labeling will be involved. And then I want also to discuss with you about another experiment of classification related to the detection of rules. So let's start from the introduction. Okay, regarding the motivation, as you can see here, there is a question. The question is, can we reason from text automatically? And actually, the answer to this question is quite tricky. It's quite complicated. And many times the answer is not positive, and mostly because in many cases, natural language is full of uncertainties, variability, inconsistencies. Sometimes it's even incomplete or misshapen. And for this reason, it's a bit difficult we have difficulties in fully connect natural language with the logical inferential dimension. So here there is a gap. We can tackle this gap by using tools from various domains, and we can, for example, use natural language processing methods, which of course are closer to the natural language. Then we can use argumentation and logic, which of course is more related to the logical inferential dimension. And then there are domains like argument mining, which are, let's say, in the middle of these two spheres. But here the point is the long-term goal is to answer the question, the big question, how can we fill this gap between natural language and the logical inferential dimension? Of course, it's a long-term goal. But I think we will need some of these elements. We will need more integration between natural language processing and reasoning methods, more integration between machine learning and knowledge representation, and more generally, more integration between sub-symbolic and symbolic artificial intelligence. So we can try to tackle this issue, employing different domains. We can combine argument mining with knowledge representation and argumentation, trying to explore this green circle that you can see here, trying to fill this gap, and trying to find hybrid methodologies of symbolic and sub-symbolic artificial intelligence. This is just to give a big picture of the motivation and the long-term goals. More specifically, regarding the experiment I will discuss here, I will. One of the experiments is related to the detection of argumentative components, so detecting the key portion of argumentative text, such as premises and claims, And the second experiment is about the detection of rules in natural language. And also in this case, it's a way to connect the logical sphere to natural language. And the first experiment can be see like in this picture, more or less, can be described in this way. It's a sequence labeling task. So we are trying to connect portions of natural language to a sequence of words, basically, to portion of argumentative structures. And so it's a way to connect the sphere of natural language to the sphere of the logical inferential sphere. This is an argument mining task. The second experiment, instead, is not a sequence labeling, it's a classification task. In this case, we tried to, with the help of knowledge representation, we tried to classify some sentences as belonging to specific classes of rules. So before watching in the details this experiment, I would like to spend some time to talk about the methodology. So we use the transfer learning methodology. Transfer learning has been a little revolution in the field of natural language processing, and I would say also in the field of artificial intelligence. The intuition behind this method is quite straightforward. Basically, you can pre-train neural architectures using big data, and this neural architecture basically learn something about language. They start learning the features of language by being fed so much this big amount of data. And the idea is that this pre-trained architecture that we call language models can be then fine-tuned, or their knowledge can be used in downstream tasks. So you can apply, you can use them in downstream tasks, and you can do that in different ways. In our case, we used a language model, a very famous one whose name is BERT, and there are mainly two approaches to use transfer learning. The first one is the fine-tune approach, which is the one you can see here in the middle. The idea is that you can use your own downstream data as an input for the pre-trained language model, and you can perform some epochs so that you can fine-tune the neural architecture, and then you can put a classification layer on the top of the neural network, and then you will have your classification. And this is the fine-tune approach. Then there is also the one on the right, which is another approach of transfer learning. Basically, you can use the language model to extract from your own downstream data some contextual embeddings. So in this way, you are converting your data into a richer and data representation that you can then use in your own classification algorithms. In our case, we use the first approach, so the fine-tune approach. So we fine-tuned some language models. So the advantage of this method are quite evident. Because basically using transfer learning, we can leverage the power of big data, and we can fine-tune our own data. And we can achieve even good results even on small data sets, which is very good. These also avoid costly methods and highly engineered features. So it's a big advantage. These kind of methods can be useful for different kind of tasks. And in our case, we used for a classification task and a sequence labeling task. So let's see the first experiment. As I said, it is an argumentative sequence labeling, so it's a sequence labeling task. And the sequence labeling tasks are basically the same kind of task performed by named entity recognition. Is exactly the same thing. Basically, you have a sequence of words, and this classifier are able to connect a sequence of words to a specific label. For example, in this sentence, we have a sequence connected to the idea of person and a sequence connected to the entity of organization. So this is what these kind of classifiers do. There are different ways of training these classifiers. You can feed them with different formats of data. For example, the bio formats is used to teach classifiers to recognize the beginning of the sentence, of the sequence, and the inner parts. But there is also another format, which is the BLUO, which also added the last token of our sequence and the unique token. We used both just to see if there was some difference in the results. Now, the idea is that you can do this kind of experiment not just to see, not just to catch people or organization, but also other things. In our case, we try to detect premises and claims using both formats. We did that using the SA corpus, which is a quite famous argument mining dataset, which is composed of 402 persuasive essays. And there are premises and claims. And basically, we performed the two tasks. In the first one, we try to detect the span of argumentative span of text, basically. And the second task is a bit more complicated because we try to detect more specifically which span of text were premises and which span of text were claims. So we tried this granular approach. The first task is the easier, and we reached very good result. As you can see, with the BLUO format, we reached 90 point of F1 score. And actually, also in the second task, we achieved encouraging results. We reached 76 to detect the span of text related to claims and premises. So this is just to show that we can use transfer learning to catch the exact span of argumentative components. And this is very important to connect natural language to the logical inferential sphere of arguments in this case. The second experiment tries to connect the language with the sphere of the logical inferential sphere by classifying rules. So in this case, it's not a sequence labeling task, it's a classification task. And we did that with the help of knowledge representation. More specifically, we used the two famous legal XML standards. One is a legal rule ML, which basically is a standard which is capable of representing the logical dimension of legal documents. And then we used the Acomantoso, which is a standard which is able to represent the structures and natural language of legal documents. So on the one side, we have the logical sphere. On the other side, we have natural language. And we combined these two formats and we achieved a data set of atomic provisions connected with their own class. And we did that with the famous GDPR, the General Data Protection Regulation. So we combined the Acomantoso representation of the GDPR with the legal rule ML representation of the GDPR. This is just the process of extraction, so the way in which we combined the Acomantoso with the legal rule ML in order to extract the labels. So I will not go too much in detail. So the point is that we created these datasets, and we were able to perform 4 classification scenarios. And the first 2 are binary classifications. The first one is a classification between rule and non-rule. The second scenario is a classification between deontic rules and non-deontic rules. The third scenario and the fourth scenario are multi-class. In this case, we tried to catch obligations, permissions, and constitutive rules. So for this experiment, we used as transfer learning models. We used BERT, which is one of the most famous language models, and other 2 related language models. So one is DistilBERT, and the other one is LegalBERT. And we use these three language models. We fine-tune these three language models on all four scenarios. And also in this case, the results are actually quite encouraging. For example, in the first scenario, we can see that we managed to achieve 88 of F1 score with the model distilled birth. In the second scenario, we even reached 92, always with distilled birth. So in the classification deontic versus non-deontic. And actually, also the multiclass scenarios, so the third and the fourth, show good result. In the third one, we reach 88, and in the fourth one, 81. So basically, we show that transfer learning is able to recognize, using transfer learning and these language models, we are able to recognize different kind of rules and different kind of deontic modalities. So the conclusion is that indeed we can connect, we can use transfer learning with sequence labeling to connect portion of text to claims and premises. So we show that we can connect the natural language to the logical inferential sphere of arguments. And in the second experiment, we show that we can use transfer learning with the help of legal knowledge representation to connect natural language to the logical inferential dimension of rules. So, of course, these are little steps, but they are encouraging steps towards the long-term goal of filling the gap between natural language and the logical inferential dimension. So that's it. These are some publications, and thank you for listening.
Thank you very much, David, and I congratulate you and Monica for this excellent and very important research to connect machine learning methods with logical representation methods within this connection between natural language and logical reasoning by connecting and extracting rules and arguments from unstructured text. Really interesting research. I will use some minutes to discussion. Let me see if there are some questions. There are there any questions from our group of speakers?
Yes, Professor, we have on the chat some questions posed. Okay.
Let me see here. One question by Laura Huescas. Do contemporary ASL and other forms of sequence labeling argumentative texts apply to languages other than English? That is, could it be applied to different languages like Arabic or Japanese, which are non-alphabetical?
Okay, thank you, Laura, for your question. This is actually a very good point, and it helps me in describing even more the utility of this transfer learning methodology and above all the use of language models. So the fact is that language models can be trained on specific language, and there are nowadays there are so many new language models coming up every day. So it's very nice area, and yes, you can find many language models dedicated to all kind of languages. So it's definitely something that can be done. So it's a method that can be applied to any kind of language. So yes, this is
okay. There is a second question by Laura Huescas. Is how does ASL deal with syntactic structures that are not written in a direct logical order, such as argumentative structures allocated in a text in a non-linear way?
Yes, this is a good question. this is directly connected to the problem that I discussed at the beginning, is the fact that language is sometimes is a bit messy, so it's a bit complicated to connect it to the logical inferential sphere. However, this kind of symbolic approach that uses neural networks showed good results also in classifying these data that are not exactly well structured. And so the answer to this question is that yes, this kind of approach can be able to catch also those portion of argument that perhaps are not very well structured. So yes, of course, in this case, we used a corpus which is actually well structured. So we needed to go further in depth in this matter, because in this case we used the essay corpus, which is a well structured corpus. So, but yes, your question is very good, and this is something that we need to explore more. But results, I'm sure that results are quite encouraging.
Okay, David, I have one question also related to this one by Laura Huescas, which addresses the complexity of the structure of arguments within natural language, and particularly with the possibility that in a text you may find composed arguments, where the conclusion of our argument is the premise of another one, and these arguments are connected in relations of support or maybe in contraposition. And how do you handle this in the classification method of the argument?
Yeah, we actually in this experiment we actually didn't tackle this point, which is a very good point. I think the goal is to create a pipeline of where we can combine different tasks. So one of the tasks can be the detection of span of text, so one of the first step of this pipeline can be this one, and then another task can be done after this one in order to give a sense to the macro structures of arguments. So this is a very good point. So thank you, Professor. I think the answer will be using a combined approach, an ensemble approach, let's say. So using different a pipeline with different tasks.
Okay, thank you very much, David, for the discussion. It was very enlightening and making it possible to understand better your tenets. And thank you also, and congratulations also, Professor Monica Palmirani. And let us then move in our schedule. We'll have now the presentation by Christoph Benzmüller and David Feumayor as our keynote speakers, who are going to talk about their research on the automation of reasoning. And in this talk, they are going to explore the subject of bridging legal argumentation and automated theorem proving. Christoph, thank you very much. Thank you very much, David, and the floor is yours.
Yeah, thank you for the invitation, first of all, to present here. Unfortunately, I'm already ahead here. And for the wonderful presentations we started with, there are many bridges also from our talk to what we have seen before. And well, we give a joint presentation here today This has different reasons, and the most important one is that David was very active actually in the concrete experiments we are talking about in the second part, and therefore we both agreed that he should also be the presenter on those. I will start with giving you the coarse-grained overview, motivational part, and the bigger picture that's driving me personally and my entire group since quite some time. You see, we have different affiliations listed here. I currently moved to University of Bamberg, starting a new research team there. David is at the moment still primarily affiliated with University of Luxembourg, and we both are still affiliated with FU Berlin. Well, what's the bigger motivation here? In order to explain that and capture that well, I probably start with my personal view on what artificial intelligence actually is, or what it should be, and also reflect on the aspect of rational reasoning, rational argumentation. And you see the aspect of meta reasoning and meta logic, and will appear in this talk. It will play a dominant role. And so try to pay attention to that aspect in particular. So, well, I don't see AI as just weak AI, where we solve specific problems like chess playing and so on. For me, it always has been a question about strong AI that was particularly interesting. So essentially the question about, can machines do everything that humans can do and possibly more? And if we think in the latter category, then I think we are talking about different layers of capabilities, or mental capabilities, so to say, that I would say are characteristic for intelligence. So at least those I consider relevant here. And the first one is the simple problem solving aspect. I solve problems in a particular domain and develop eventually some very specific techniques for solving them in a particular domain. Or the second one, we all know that, for instance, we are capable as humans to explore and act in unknown territory. And when we send a rover to the Mars, a system, of course, to a certain extent, need to have such capabilities. But it's more than those two layers. It's in particular also abstract and rational reasoning that is to be found in humans, at least. I mean, think about the exploration of a mathematician, of a new mathematical theory. Sometimes in metaphysics, we develop new theories even without any data to start from. Think about ontological argument for existence of God, for example. Now, there's a fourth layer I find very relevant here, self-reflection. So this is connected, of course, to being rational, to detect own mistakes, to be able to see that my reasoning is not aligned with, for instance, my goals, my values, or is even contradictory to some extent. And at a fifth layer, it's about capabilities in direction of social interaction. So to take goals, values into account, which may interact with the other layers and might have a significant influence on the way your rational reasoning in a particular domain behaves and works. Well, and you see with machine learning, I think at the moment we are addressing only part of the picture here, maybe levels 1 and 2 to a certain extent. But in particular, when it comes to the abstract and reflection and so on, at the moment, we don't see much of that. And here I agree a lot with the previous speaker. We need more research in the direction of hybrid AI. So exactly techniques that he presented that bridge between symbolic and sub-symbolic AI, or the other way around, are very important at the moment to research. In particular, because of that here, I think what we have at the moment is visions of weak and unreflected AI. And we may ask ourselves, do our today's AI systems actually know what they are doing? Do we know what we are doing when we let such systems decide on very critical issues, eventually even about life and death, think about autonomous weapon systems and so on? And is unpredictability and normative orientationlessness a core characteristic of future systems? You see, I very often have this nice poster here with the German title, this James Dean movie, Rebel Without a Cause in English, but the German translation is nice. It says, denn sie wissen nicht, was sie tun. So this young generation of teenagers, which more or less lost their, let's say, moral or normative compass and so on. So it's probably that's how I see current AI development. So we build systems that actually don't know what they are doing, and we let them even decide on very critical things. So we need to think about ethics, norms, law, means of rational control. And as I said, we need more in direction of hybrid AI technology. And here I want to refer in particular with hybrid AI to a recent article by Wolfgang Biebel, just appeared in German in the Informatik Spektrum. You see it here on the right. And he's arguing here, or actually explaining here that AI in particular, this aspect of symbolic AI as part of hybrid AI is actually about studying the study of abstract representations. So he calls them representing objects. So they are key to symbolic AI. And these ROBs, these representing objects, can of course be experimented with in the computer. That is what we do with automated T improvers when we develop logics and automate these logics and then manipulate symbolic representations. And in this sense, representing objects, in a sense, might even be considered now physical, accessible to some extent, because they're in the computer where I can manipulate them and where I can experiment with them. In a sense, you can see here symbolic AI and logic in combination with just computer experimentation, even as a step in direction of a shift from considering, say, more and more the science of working with representing objects as an experimental or natural science. And I've given examples before. You think about mathematical objects or theories in metaphysics, think about legal theories and so on. And in this talk here, this is very important now to pay attention to, we even question the underlying logic. So unlike the first talk, for instance, which started with a fixed logic, we here in this presentation say, no, we want to make the underlying logics itself an object of study, a representing object, which we might want to manipulate in the system on the fly. So that means our experiments of that form here. We have humans involved, typically a domain expert, which presents an argument, semi-formalized or natural language argument that is then hand converted into semi-formalized and in the end, fully formalized representations in interaction eventually with the computer scientists who understand the T-improving machinery that we are using. And you see, it's about representing objects that cover both logic and the aspect of argumentation. So the logic becomes negotiable. I point to that a couple of times in the presentation. And then we conduct experiments on the computer to see whether we can automate arguments, verify them, refute them, find problems, find paradoxes in the setup, and so on. And this is what we have done for quite some time. And the methodology we use is logic-key. I would say a few words about that, and we will have more when we come to the case studies by David. So unlike Leibniz, who thought that there is a characteristica universalis we should use to reason in metaphysics and morals in much the same way as in geometry and analysis, I don't think that we can do it at the object level. But our approach, the logic-key approach, says maybe we can achieve something in that direction if we consider an universal meta-logic, in which we then also address different logics as we have developed in the past century in particular as objects of study and combine them eventually. So we make objects, the object logics we want to encode arguments in itself as objects of study that we represent and manipulate in the computer. This is well explained in this article here. And here you see a picture again, what we want to do. We take a sufficiently rich meta logic, classical higher order logic in our case, in which we then encode, semantically embed the logics of interest and combinations of them, and then use those to encode the material in the domain of application. This is another picture which symbolizes that, and it's well explained in this article here. So Hall is our meta logic. This is the only thing that is fixed in the picture. Object logics become negotiable. They are themselves studies that are represented explicitly in the approach. Then we use them to model our domain-specific aspects, our knowledge base that we need in a particular domain, and then encode the applications and hand this over to T improvers for whole, which in a sense now become universal logical reasoners for all the layers above. And we have done that in different domains. For instance, in the domain of metaphysics, where we looked into simple arguments, but also much more complicated foundational works in metaphysics, foundational theories. But for the ontological argument, there's a nice reference here together with David, where we then, again, applied the approach. Metalogical was fixed. We encoded intentional higher order modal logics. We modeled ultra-filter theory in that and looked then from the perspective of ultra-filter theory on Gödel's ontological argument. But here in the course of this talk, it's more interesting now to apply this methodology and framework and the tools to value-oriented reasoning in a legal domain. And again, all is fixed. We use, for instance, in one of those experiments you will hear more about by David, modal logic of preferences. We, on top of that, encoded a value-oriented legal theory in which we then assessed and modeled and assessed some legal cases, in this case, wild animal cases that are well known in the legal literature. So there's a reference to a preprint of this recent work, which I recommend here on the left-hand side, and you hear more about that by David later on. Here's the picture, how we now connect to the T-improving world. I mean, the title initially covers bridging legal argumentation to T-improving. So we're interested, say, in applications in machine ethics, and we want to encode some legal constraints for AI systems, say. Or some particular ethical theory, for example. And we want eventually to work with deontic logics. They become now a study object themselves. We model them in classical higher order logic, so that can be changed later on. And on the fly also combined with other logics as we need them. Now, these embedded logics then, here deontic logic, unfold then in representation in classical higher order logic, which makes it now possible that we can call T-improving technology in systems like Isabelle Hall, but also other interactive T-improving systems could be used here that provide similar bridges meanwhile. Lean and others are on the market, and they provide then bridges to T-improving technology, like state-of-the-art first-order T-improvers that typically internally, again, collaborate with latest state-of-the-art SAT solvers, or, and that is very important in my own experience, also to model finding technology, counter models. Very often, your argument is not correct. Very often, you have a problem with it. And you are interested in finding out what the problem is. And then a counter model can, of course, help a lot to find out what the problem here is. And this we have experienced a lot. So these model finders in this methodology are highly useful. And of course, this here also supports then research, education, and application. I've talked mainly about application or research-oriented application, but education part should not be forgotten about, because you can now very nicely, in a uniform framework, introduce different logics that are relevant for argumentation. For example, deontic logics in the legal case. So this is what we do at the moment. Humans are still involved typically, but lots of the arguments can already be automatically verified, and dependencies can be found out automatically and so on, but still the human is in the loop. In the future, it would be interesting now to see how far you can push that in a direction of an automated, or at least partly automated, assessment of arguments in the computer using this technology, where you, for instance, want to find out which particular kind of logic can explain this corpus of arguments I have. So not the other way around, that we a priori assume that the logic is fixed and then deal with that. I don't think that this is the right way to look at the general problem here, but we can debate that later on. So I think I've talked enough at that point, and I want to hand over to David, because he will present you now with some experiment or case studies we have conducted. I stop sharing and hand over to David.
Okay, hello. I will start sharing right now. Give me a second. I hope, can you see my slides? Yes. Can you see them? Okay, yes. Perfect. So I'll start from here. So for the case studies I will be presenting right now, we are taking the so-called theory construction view on legal argumentation. So we have this quote by Thorne McCarthy, which I will read, as says that the task for a lawyer or a judge in a hard case is to construct a theory of the disputed rules that produces the desired legal result, and then to persuade the relevant audience that this theory is preferable to any theories by the opponent. And we will sort of merge this philosophy, like of conceiving legal argumentation, with Leibniz Calculemus Manifesto, which Christopher already talked about and you already know. It's quite famous. It says that if controversies were to arise, there would be no need of disputation between two philosophers than between two accountants. For it would suffice for them to take their pencils in their hands and sit down at the abacus, or the computer in our case, and say to each other, calculemos. So if you know the story, Leibniz had this idea of having a machine that is able to decide if an argument is correct or not, or to decide who's, to solve these sorts of problems, or given an adequate input. So nowadays would say the adequate input for such a machine is a logical formalism, and the machines that they implement this in the modern times would be what we today call automated theorem provers. And as we conceive of them, how we apply them for legal reasoning consists in that first we model a case, say a legal case, as a set of facts, F, and the decision. And the idea is that we can, on the one hand, prove or verify that the decision taken according to the facts modulo a background set of legal knowledge is satisfiable. I mean, we cannot derive a contradiction. Or we can use these tools, automated theorem provers, to verify that, in fact, the decision logically follows from the facts, encoded facts, modulo a background set of encoded knowledge. This can be ontologies, lexicon, taxonomies, etc. And we get an answer from the machine, if it's compliance or violation. So the question is always which logic to take from this, because we know we have a whole slew of different logics in the market. And well, the answer is it depends, right? So it depends who you ask. So people in the formalization of mathematics or for knowledge representation for very expressive formalisms, in case of mathematics, for instance, who use these proof assistants we will be talking about, they would say, okay, just take an expressive enough logic, so a higher order logic, and you can encode everything using a higher order logic, because a higher order logic is very expressive, so you can embed all of these logics. But another similar approach would say, okay, let's actually use these logics as first-class citizens, but conceiving of a translation of them into an expressive formalisms, like higher order logic that will work as a sort of underlying soil for these logics. And but we have other stakeholders, right, with whom we need to communicate, and to which maybe we cannot just present logical formulas. They may not understand them, or they might be also technically literate and know and maybe program and things, but they may lack this very particular specific knowledge of say, the ontic logics. So for them, we can put at their disposition some sort of a domain-specific language, which also has the advantage of being, in a sense, also machine readable. And well, we have the domain experts, of course, maybe lawyers or ethicists who say, okay, whatever works, they are concerned more with the domain, with the domain specific things, not the technicalities. So we need to keep all these people happy. And for this, this methodology Christoph already talked about has been developed. So I won't talk more than that. Just to mention that the idea of the logic key methodology is to encode knowledge and problems at different abstraction levels, and then translate formulas or knowledge from layers down to our underlying meta logic, which is this higher order logic. And this allows to keep on the loop different specialist roles. So domain experts, knowledge engineers, but also people who do logic and programmers too. And this the idea behind this is to get some sort of a division of labor. So everyone can keep doing what they're best at doing, but communicate with each other. So I will just fly above this part, which is the part how we encode object logics into the meta logic. So Christoph already talked about this, and we have some literature on this topic by Christoph and colleagues. And the idea is that this higher order meta logic takes the role of that English takes when discussing a logical system. So English is like a meta language, and our meta language will be a formal language, a higher order logic type theory. And we use this theory to encode the syntax and the semantics of an object logic. So it looks, metaphorically, it looks like this. So the idea is that we make definitions, so as equations, in which we define an object logical connective in red, and we say this is equivalent to some particular expression in the meta language. And it looks like this. So let's say for negation, it corresponds to this term in the meta language, or for the modal logic, a box operator corresponds to this term in the meta language. You don't need to go into details of what this means, but this is the overall idea. And it looks like this. These are screenshots from a theorem prover, from a proof assistant. And we can just look here first at the beginning and just show how, more or less, how it's encoded. We defined an abbreviation. We give it a type because it's a typed meta language, a typed logic. We introduce notation and encode the equation. Basically, we say, okay, this connective now is equivalent to this expression in the meta language. And the idea of doing this is that we can combine logics also by adding and removing these expressions in the meta logic. And for the case of modal logic, for instance, we can write constraints, right, on how these connectives are supposed to begin to behave. And doing this, we have encoded many different sorts of logics, and the list is growing. And now to logic key, I will in the remaining 10 minutes or so, I will present one, or maybe I can discuss a second use case, a case study. So for the first case study, we have this very famous legal case, which many of you are also know very well, which is Pearson versus Post. So I will just discuss it succinctly. And Post is a fox hunter who was chasing a fox through public land, and then came this guy Pearson, who just came across the fox, and knowing that it was chased, killed the fox and took it away. So Post sued Pearson for damages, and arguing that giving chase to the fox was sufficient to establish possession. So after some appealing in the local court, the final decision has it that Pearson was right, and that legal stability outweighs the will to possess. So that this means that the fact that the person has the fox in his hand, it sort of promotes the value of legal certainty, and it's overcomes or outweighs the claim by Post that he was giving chase to the fox is sufficient for possession. We have a similar case, a modern, more contemporary case of Chester, which is this beautiful bird here, which was found by an animal shelter and was escaped and was recaptured by this guy Conti. And the owners of the bird reclaimed the bird back from Conti, and they sued, I suppose. And the court ruled in favor of the animal shelter. And in the argument that they say, okay, and in this case, legal stability does not outweigh what we name here will to possess. And for the case of domestic animals, because for domestic animals, this bird being considered in this case, it counts as a domestic animal. It's sufficient that the owner did not give up the responsibility for the maintenance of the bird, and also the reliance on property. So we call them these things here values, and the combination of they overcome legal stability. So fostering or promoting these two values is stronger than promoting only stability. So this was basically the argument. And we were working with Bertram Lomfeld, who is a professor of law at the Free University of Berlin. And he had developed this theory during the last years, whereby he proposes a basic set of what he calls value principles, and which are given here in this diagram. And we team up with him, and so with Christoph and me and this legal theorist to encode this theory. So how to encode these cases using this basic set of values. And we came up with a formalization, which I will discuss succinctly in the next couple of slides. It looks more or less like this. So, and in the end, what we do is we can write in a proof assistant that given the plaintiff's theory, and given a plaintiff's theory and the plaintiff facts, a decision for the plaintiff can be automatically derived, and the system already suggests which these things here they stand for, which background knowledge or which definitions are needed for this. And we see we can derive the decision for the plaintiff while taking into account the background theory of the plaintiff, and we can do the same for the defendant. So I will just go into the details for this. So what this actually means, right? And okay, this is how the logic key methodology gets instantiated for this case study. So we keep the meta logic fixed at the bottom, and you use as a object logic a model logic of preferences, and on top of this we encode this what we call a value ontology, which is this theory proposed by this legal theorist, and we use this to encode legal knowledge and decide or showcase how these automated tools can decide these cases. So as for the theory of Lomfeld, well, the idea is to encode this sort of legal knowledge as conditional value preferences. So we have an example here. So if a virus pandemic occurs and contact tracing fails, then health security outweighs freedom to move. So we have these two values, and we have a relation that one value outweighs a second one. And the idea is to develop a domain-specific language, whereby this sort of rules look like this, like the aggregation. Here, for instance, security aggregated together with freedom to move. That freedom to move outweighs security in this case. And this can be also combinations of values. And this preference relation is conditioned on some preconditions, right? Which is in this case, for the example that we have a virus pandemic, the contact tracing fails. And we can also assume some other restrictions that make sense for these operators of value aggregation, for instance. And we discussed them with our domain expert, and we agreed that these two first were actually highly desirable to have this inference, but not this one. And this property here, we said, okay, maybe it makes sense or not. They're just formulas. You need to go into details. But the idea is that given these constraints, we could employ a logic which was already in the market, which is developed by Van Bentem and colleagues, and which is a modal logic of ceteris paribus preferences. And the idea is that we encoded this legal domain-specific language by, first of all, by saying that our value and preference relation would correspond to one of the value preferences defined in this logic. I won't go into details. And we also came up with an idea, with a way of mathematically modeling also this value aggregation connective. As an interesting side remark, it's also possible to define a diffeasible conditional using this model logic by Van Bentem and colleagues. And we have more details in the paper. And we also created some terms which are part of our domain-specific language, which correspond or translate into terms of this object logic of preferences. This is how it looks like encoded in the Isabelle proof assistant. I won't go much into details here. I just want to show you how it looks like encoded in the computer. So we can have some example legal or word knowledge. So, for instance, the appropriation of the animals it implies appropriation of objects. This would sort of count as rules if you want. And we have also this sort of legal knowledge expressed as I said, as conditional value preferences. For instance, we have here the combination of these two values outweighs this other value, and they are also labeled for the party. So if X is a legal party, let's say the plaintiff, then this notation means the defendant. It's just notation. So fostering a value for these values for the plaintiff, outweighs the fostering this value for the defendant. Basically, what it means. And we can encode the legal in word knowledge using this way. So, okay, so there's some word knowledge about animals, and we can also encode some so-called factors. So, there are many different factors that we encode for the sake of modeling these examples, and also this term, which means that basically that deciding for one party, given that the party, the legal factor intent applies to the party, fosters or promotes the value of will, or this is the set of values proposed by Lomfeld. And just to finish here, and I show how we decide a legal case using this theory. So we start by encoding what would be the defendant's theory. For instance, we already have this background knowledge. We encode here which are the facts. Oh, sorry. I'll set an alarm that the time is over. And so just to finish, this is the defendant's theory. So this is the claim by Pearson that there is an animal who has been captured, that the animal is not domestic, and etc. And those are the facts, like the situational facts claimed by the defendant. So it claims that the fox was free roaming, that it's not a pet, that it's been pursued by the plaintiff, but captured by the defendant. And given these facts, we've been actually able to derive this as a theorem. So basically, given this, D theory is just this conjunction of these sentences, right? D facts is just the conjunction of these situational facts, which are, and we're able to derive automatically that the decision for a defendant can be taken. And these facts here, which are the background facts that are used for this decision, they were automatically suggested by this tool called Sledgehammer, which is integrated into the Isabel proof assistant. So this is sort of abduction, if you wish. And we can also explicitly reconstruct this proof in the proof assistant, just to give a more explicit argument. And so I will stop here, and thank you for the attention, and just referring you to this, our preprint, where this work is presented in more detail. So thank you very much.
Thank you very much, David. Thank you very much, Christoph, for this excellent talk. And congratulations for the research, which is really very important. It's the mainstream, the frontier of research on, on the application of AI to law and legal reasoning. There are many questions that I would like now to address and give room for people to propose these questions and discussions. First, I will give the floor to Michał. Michał, please.
Thank you very much, Juliano. Excellent talk, gentlemen. Congratulations. Fascinating. I would have a very specific question. In the model of case-based reasoning incorporating theories and values, Trevor Benchcapan and Giovanni Sartor introduced some external criteria enabling theories evaluation and comparison, including consistency, the expressiveness, the ability to explain as many cases from the database as possible, and the scarcity of the used predicates. Are you considering using similar criteria in your model?
Well, I mean,
David, go ahead. Yeah,
I take the question. Yes, we're aware of this work because actually it was one of the. I mean, the theory construction idea actually came by reading their work. So we from reading their work, we came up with the conceptual framework how to explain what we are doing with this proof of systems. I'm aware that they developed this much more, but we haven't integrated these particular things that you just mentioned. We're not yet there. So we're taking a parallel approach, but it's an approach that is inspired by what they do. What we do use is factors like, I guess it was Hypo system that introduced them. No, Cato, I guess it was. But we are inspired in the factor-based approach too. But we keep enhancing our model, and what you suggested is a clear feature work we're interested in.
Yeah, it would become, just to add on that, to that, taking into account such criteria would be particularly interesting when, in reference to the last slide I have shown, where I said, can we do more of that automatically? And if you then have a meta process established that use the framework we have, where we have access to many of the variables, so to say, then of course, I mean, it can only be automated if you have a kind of meta guidance mechanism. And there you need, I think, exactly such criteria that at the moment, the human interactive user has to more or less take care of. And so there's clearly opportunities for taking them into account. But how, the question essentially is, to what extent can we put them, and can we take them as a recipe for automation of such a meta process? Yeah.
Thank you, Alex Knoks.
Yeah, thanks so much. Great talk. Very impressive work. So my question is, I sort of have this feeling that we have like an abundance of riches here. I guess the question I have is, once you are able to see these logics as an object of study, right, and combine them as you were saying, and then I guess arguments will come out valid or invalid depending on which logic you're going to use. And then there's this question of well, what do we do if how do we decide which logic to use in this specific case? And I was also thinking of the case study that I guess what you've used this, like, a domain expert was Blomfeld, right? And then you used a specific logic of von Bentham and other people. And then at the end of the day, you have you have this machine that lets you decide cases. But what if someone else used a different logic and a different theory, legal theory, and also followed the logic key framework and their framework? They would get the exact opposite results of what your specific theory is providing. How would we go about resolving such a case? Is my question.
Yeah, excellent question. And it's exactly this sort of experiments which we conducted on the ontological argument, because ontological argument for existence of God, and a small, crisp argument that comes in essentially, let's say, kind of small adaptations, variants. But the interesting thing is that different authors have also proposed different logical settings: intentional logic versus or an intentional modeling of a notion of positive properties in the argument, whatever that is now, versus an extensional modeling. Then there have been proposals of, the argument is valid in modal logic S5. Actually, theorem provers then in our experiments confirmed that another author who said, no, you can already find proofs in modal logic KB is right. The latest experiments show that you can already derive it essentially in base modal logic K and even simplify it and so on. So it's exactly this kind of thing that we have conducted over the last 10 years and contributed with that to the debate on the ontological argument. We found even inconsistencies in some variants, and then could say, look, this variant should not be further debated in exactly that form because this is inconsistent. Rather use the other one. You're completely right. At the moment, it's always then the human who has to decide, or in this, what to take out of this. I mean, the theorem provers give you that sharp knowledge, eventual counter models, or they say, hey, inconsistency found, and I give you a proof why. And then the human has to negotiate and negotiate that with the other colleagues. What is now a good variant? But this is already useful in itself, because in this area, you could now, for instance, rule out certain of the variants. You can say, oh, this has a more simplified alternative, so why not considering this? So it can inspire their research progress, because the machine is eventually capable of producing many of such argument alternatives or fine simplifications very quickly. And these kind of things are interesting in itself. Now, to what extent we in the future might be able to now put more and more of this meta-level debate that's currently done between humans into the machine is a good question. So I don't know yet. It's more or less referring again to the picture of the last slide I've shown, and the question we had before. So what kind of criteria can we now take to say this should be the logic for this particular context, and this should be the right way of modeling things? And I think the only chance I see right now is to start with a good set of clear criteria, and then have a flexible machinery working with this criteria and finding it out. But still, the criteria would come from the human. Or if we combine it in the long run with, let's say, more hybrid AI technology, you can eventually work with large corpora and try to detect a kind of common ground for logics that are used in in the corpus and large corpora of natural language arguments. So is there a logic that can explain all the phenomena I want to have explained here and doesn't have phenomena that I don't want to see as positive examples, for instance? So maybe such questions can be asked in the future, but I think we have many things to do on the robustness, on the scalability of the technology we have shown. So there's a lot of technical issues also still involved. But on the meta level, in this interaction between human and machine, you can see already some very useful patterns that can create new knowledge and help create new knowledge in the interaction, not yet fully automated.
Okay, before focus on the questions by the audience, I have a question too. Well, I think that the main one of the important challenges is how to build these theories that explain cases. And for instance, you have shown in your experience quite well that given a set of preference between values, we may solve these cases and represent the solution of the case quite well. But the question is, when there are new cases that appear, how are these theories constructed? So how can you extract preference relations from a set of cases? And I have been struggling with Giovanni Sartor to try to represent this. And one of the ways we are trying to pursue is to use revision models to represent the fact that actually in the construction of such theories, rules and are changed, and also values, the hierarchy of values are changed in order to build a model. So in our model, we use value weights and impacts, so that we can have an assessment of how strongly it addresses, numerically, it addresses a particular case. And but we also have the fact that to address this case, you may have to go through some changes of the rules. So this connects with what Michał has said, because using this, we may have we may represent this criteria. For instance, changing less the law to achieve a theory is better than changing more the law to achieve an explanation. Having a better numerical value that adapts to the case, so a stronger, it would be a stronger explanation. We may use this. So I'm very interested in what you're doing to try to explore now the other way around. Instead of having the model and prove the cases, how we go from a set of cases to build the representation, to build an explanation. So if we could explore a little bit this issue.
Yeah, good point. David, do you want?
Well, I can just tell a short remark and you can complement it later. But so, as I understand, the question is how to bridge like from the purely deductive, like we have this mathematical model, we give it input facts as input and conditional value preferences as input, and then we decide cases. That's what we showed here. So your question is how to get these conditional value preferences out of a set, yes, let's call it
case, maybe some sort of abductive reasoning to
exactly. How do we abductively derive these conditional value preferences? And we've had some methodological work previously on this. But I'd say the idea is basically by reconstructing cases. So we take this let's call it a data set of previous cases, decided cases, and we try to fit which value preferences are the most suitable out of this. So actually we did in a sense this because we knew that here Pearson is supposed to win to to post in this legal case, and we abductively came up with the value preference that we encoded in the theory, which is that will to possess outweighs. No, sorry. On the other hand, the other way around, that the stability outweighs the will to possess. So this value preference was we abductively put it on the background knowledge because we knew that assuming this, a person will be the winner of the case. And if we have a training set of many of these cases, we can abductively come up with these conditional value preferences. And I'm aware that Longfeld, the person who suggested this theory, he was aware that he's been doing this by hand, like looking into literature on cases and also mostly cases and abductively getting these conditional or contextual value preferences, because they're value preferences, but they're not universal, but they only hold in particular contexts. So that's what he.
Yeah, but it doesn't fully answer whether we can automatically generate now out of a given small corpus these rules automatically, right? And I think there's much room for collaboration with other approaches or parallel approaches, and to find out in what way you can benefit from them or integrate them in the picture. So, lots of the experimentation still, we have to be honest here, have to be done interactively. So, for instance, David, of course, that wouldn't be hard to fully automate that, right, David? The point to find out what the right form of aggregation and the preference relation we did choose. In the end, we went through all the cases and experimentally went through experiments, and then in the end had just a few choices left, and we picked them out of those. This can be automated. I mean, in the case here, but it was still done by hand in the current experiment.
Yeah, we need some sort of abductive logic programming, but for the higher order case, basically, yeah.
Okay. Thank you. Now I'm going to move to the questions by the audience. There is one, I think it's directed to Christoph, because it touches on your personal motivations and philosophical motivations. João Pereira asked, do you believe that the logical system and eventually a strong AI would have the ability to provide better answers to human evaluative problems? Could the logical goal be able to replace human evaluative weightings in ideal structures of precision?
Well, I personally think it's a long way to go. And if you take my original motivation, why I entered the field of AI, that was exactly to prove that humans are superior in many respects to machines. So I got caught by a quote of a professor in the early 90s who said, well, we are now at the beginning of a time where we experience a new branch in the evolution, where we have a new form of intelligence emerging on different biological grounds, and it will in some sense not only superior to human intelligence, but self-reproduce and so on. So I was shocked by that comment. I thought, no way you will make machines doing that. And I'm still trying personally to disprove that this will happen, so that the super intelligence will emerge and that machines are superior. So I think there are certain questions not sufficiently answered yet that would make think that this is not going to happen. In particular, not by the current machine learning technology, without the capability of producing representing objects out of learned, so together with learned models and so on, and then to make the learned theories or the learned knowledge symbolically represented again, studies of object and accessible to machine learning. So if we had that robustly and really with layers of self-reflection and so on, and or seeing that you can see these forms of self-reflection I've been talking about also somewhere present in these methodologies and approaches, then I would think, yes, we are on a way that machines could become superior and really good in that. But I'm personally not fully convinced yet. I think we can do much better than we currently do, in particular if we go in the direction of hybrid AI. But whether we can surpass human judgment at any point, I'm still not decided. I have to be honest.
Okay, thank you, Christoph. We are a bit ahead of time, but there is one last question here by Marie Mesidor. Actually, it's connected with my question too. She's asking, I'm assuming this model was applied to cases already resolved. What if in the course of a case, new facts show up? So how do you build the model when variable facts is incomplete?
I'm not sure whether I fully got it.
Actually, she is also asking how the model could be reconstructed to apply to new cases where new factors are shown to be relevant. I think this is her question.
Oh, right. Yeah. I don't have a convincing answer yet. So it's true that at the moment also this on the level of the knowledge base and the explicitly represented knowledge, a lot was handcrafted, and we don't have automated means yet there to automatically extend it. At the moment, there's still humans critically involved in building up these new pieces of information, and then to engage in a new series of experiments with respect to the extended knowledge at that layer. And there's definitely more research needed in that regard to automate processes at that level. But on the other hand, the interesting aspect is really counter models that are being produced. So if you have new cases coming up in, or new interesting questions you ask to the system, and the first thing you would typically get is counter models, and these counter models then eventually tell you a lot about your shortcomings of your current modeling. They tell that, again, the interactive human user, and he has to make sense out of that and then see what is going on here. Do I need to do something on the logic side? Do I need to do something on the side of the domain modeling, the domain specific language, and so on? And automating that is not clear yet to me how that could happen. David, do you have something more to add here?
No, nothing particular to that. I mean, if new facts come in, we have to include them in the theory and run the provers again. But that's the current state.
Yeah.
Okay, thank you very much for the very nice talk, and thanks for the audience for the questions, and I think it was a very rich discussion. Let us now move then in our schedule. I will give the floor now to Michał Araszkiewicz. I don't know if I spelled it correctly, Michał. Michał is assistant professor at the Department of Legal Theory at Faculty of Law of the Jagiellonian University, Krakow, Poland. He was also the chair of the URIX 2014, and is a very active player in the field of AI and law and in the community of AI and law. Thank you very much, Michał, for joining us in this seminar. The floor is yours.
Thank you very much, Juliano. Thank you also for your kind invitation to participate here. It's a great pleasure. So let us move on to the presentation. It's called legal justification structure. The word legal is taken into parentheses because, in fact, I believe that these considerations have a more universal scope of application. However, the legal domain will remain our illustrative battlefield, so to say. So this is a legal philosophical contribution. And what is the motivation here? Justification is a crucial concept in all fields of human discourse. In practical discourse, that is the discourse involving what should we do, what are the proper patterns of behavior, the notion of justification is applied both in the field of law and ethics. It is also very important for AI and law, where modeling legal justificatory reasoning is essential, and for the current discussion concerning the normative, legal, and ethical aspects of AI. In particular, it is worth emphasizing that explanation of the functioning of a system is not tantamount to justification. The very notion of justification is still quite elusive in spite of the decades on philosophical research on the term, so I believe it is worthwhile to reconsider the foundations once again. To emphasize it one more time, justification of a decision is not its explanation conceptually, although they may be coexistential. So the same set of propositions may play the role of both explanation and justification of a particular decision. So let us move on to this foundational conceptual scheme. We may ask ourselves a question: what can be justified? And these objects may be divided mainly into three categories. So first, propositional attitudes. So adopting a certain attitude by an agent towards a proposition. Proposition is in turn something that represents a state of affairs. So I may believe that the cat is on the table. I may doubt if a cat is on the table. I may also accept or reject that proposition. Also, decisions can be justified or not. Very often, adopting a particular propositional attitude precedes logically and temporally adopting a particular decision. Last but not least, actions may be justified. So the objects that can be justified, they all somehow relate to some agents. The situation is quite different with regard to what can justify. We might say that any object, like fact, proposition, or belief, may be the source of justification. So for justification of adoption of a propositional attitude, decision, or an action, provided that there exists a rule according to which this object justifies whatever is justified. That is a propositional attitude, a decision, or an action. For the sake of simplicity, in this presentation, we will focus only the justificatory relations between propositional attitudes and in particular between beliefs. So we'll consider how adoption of certain beliefs may or may not justify adoption of other beliefs. These considerations lead us to the notion of justificatory framework, which encompasses two parts. That is the two main parts. That is a justificandum, a set of beliefs that is to be justified, and a justificans, that is a set of beliefs that may provide justification for beliefs included in the justificandum on account of the set of justificatory rules. So here it appears that the notion of justificatory rules is in fact crucial here. The notion of justificatory rule cannot be debated if we do not grasp some general account of a rule. So rules may be accounted as entities which connect to states of affairs or sets of states of affairs. At this moment, we don't presuppose any particular ontology of rules, so they may be accounted for as mental objects or, for instance, as ideal objects in Popperian third world of a certain type. Rules can also be propositionalized and expressed in language. Then we have linguistic expressions of rules. What is important about the rules is that they have world-to-world or mind direction of feet. So if the world does not conform to the rules, then in this micro context, it means that there is something wrong with the world and it should be amended in some way. Justificatory rules in our account connect the state of affairs that there exists a set of justifying beliefs, that is the set of justificans, and the states of affairs that another belief, that is the justificandum, is justified. We can speak first of justification, which is relative to a particular agent's belief set. So we may state that an agent A has justification to believe that P, with regards to this agent's belief set, if there is a set of justificatory rules, on account of which believing in the beliefs in this set S justifies believing that P. We have to note that the agent A may not be aware of this fact. So it may have justification or a belief, yet fail to actually believe in a particular proposition. So several possibilities emerge here. So it's possible that agent A has a justification for believing P on account of its belief set and actually believes in that proposition. It may not have a justification for believing that P and not believe in it. It may not have a justification for believing that, but still it may believe in it. And finally, it may have justification for believing that and does not believe in P. So the mistakes, the errors of the agent may follow from the misapplication of justificatory rules. Justificatory rules, by definition, cannot be entirely private. The very notion of the rule implies some degree of generality and communicability. So far, we have focused on a existing set of beliefs of a particular agent. But we may also notice that a belief set of a particular agent is not properly reconstructed for many reasons. So we may also speak about the justification relative to a rationally reconstructed belief set. Then we can claim that a given agent is justified in believing P with regard to a potential rationally reconstructed set of beliefs if there is a set of justificatory rules on account of which believing into this rationally reconstructed belief set justifies believing that P. Of course, the criteria of rational reconstruction of a belief set may themselves be questioned. A belief that a particular C is a good rational reconstruction criterion of a belief set may itself be subject to justification and justificatory reasoning. So, taking into account the possibilities that we have here, we may combinatorically reconstruct 8 different situations, which are, I think, all interesting because they depict different cognitive situations, so to say. So the variables here are whether agent A believes that P, whether it has justification for believing that P with regard to its specific belief system, and whether A is justified in believing P with regard to potential rationally reconstructed belief system. Here we assume that this rationally reconstructed belief system is fixed, but in reality we perhaps could reconstruct at least a few competitive rationally reconstructed belief systems. So how legal justification can be characterized against this background? Of course, we have different spheres of legal discourse. So there is, for instance, the field of legislative discourse, law applying discourse, the discourse of legal philosophy, the discourse of particular types of legal doctrine, the discourse between corporate lawyers in connection with the negotiations, and so on and so forth. The justificandum here, though we may generalize it, is some belief about the law, about a legal decision or legally relevant action, which is justified in particular situation. And the set of justificans are the sets of belief about the law or about the facts of the case whenever relevant. These beliefs about the law may concern, in particular, this list is not exhaustive, the very nature of law, the notion of legal validity, the interpretation of particular legal sources, applicability of legal norms, the choice of legal consequences, and so on and so forth. This list is not exhaustive. And so the question emerges here, what are the justificatory rules warranting acceptance, believing in certain justificanda on the account of prior acceptance of certain justificants? There are several answers to this question, which have been discussed in legal theory. One of the earlier answers to this question refers to the idea of law as a deductive system. So if all legally relevant content may be represented in the form of logical formulae, then the rules of justification are tantamount to the rules of classical logical consequence. However, classical logic, deductive logic, proved not to be most useful in numerous legal contexts. So then there comes the idea of law as a divisible theory, where classical logical consequence is substituted by non-monotonic consequence. The non-monotonic logics, divisible logics for law, proved very useful for the sake of modeling of the process of legal argumentation. Quite in parallel, the theories of legal argumentation have been developed in general legal philosophy, and they emphasized non-deductive steps in legal justification. So kind of answer to these doubts, these problems, is the reconstruction of law as argumentation framework. In the field of computational argumentation, the justificatory rules in this context may be accounted for as argumentation semantics. That is, certain principles that warrant joint acceptance of several subsets of initially given sets of arguments and rejecting some others. These eventually rationally acceptable subsets are referred to as extensions generated by semantics. As of today, we know that non-monotonic account of legal justificatory rules and argumentative semantic-based account of justificatory rules are closely connected to each other, as a lot of formal results have been proven that the models of legal argument satisfy Jungian semantics. Finally, we may think about the law as a coherent whole. In this account, the justificatory rules are the criteria for assessment of the large portions of propositions or beliefs that are taken into account here. And these criteria may be external, like in the case of the theory of Bench-Clapen and Sartor discussed today, but they can also be considered internal criteria, parts of internally coherent wholes, the adoption of the latter view, of course, leads to incommensurability of the generated theories, because they may be looked upon as relative maxima. So the best theories we can arrive at, assuming that particular criteria are concerned. However, not everyone may accept this criteria. This finding also a bit explains the very fundamental phenomenon of disagreement within legal philosophy and particular legal doctrine. In this connection, it is interesting to take a look back into the works of very influential American philosopher Charles Sanders Peirce, who famously analyzed the development of science, the evolution of science, and he had this idea that eventually the theories developed in the field of science will converge in order to develop a general theory of everything, so that the competing paradigms will be to some extent unified. It is an important question whether this ideal may be applied in the field of law, especially in the pluralistic communities. So these considerations give us interesting insight into the notion of legal logic. In legal theory 50 or 60 years ago, there has been a debate between the views whether there exists something which may be referred to as legal logic. So some of the scholars take a stance that there does not exist any specific legal logic. Of course, legal reasoning may be reconstructed in accordance with the formal logic patterns, but formal logic is a formal logic, period. We may populate the databases, the knowledge bases, with specific legal knowledge. However, the reasoning patterns are more universal. They are no domain specific. And then there were different scholars who argued that there exists specific legal logic because lawyers have an inclination towards, for instance, rejecting certain conclusions that are otherwise warranted on the basis of logical reconstruction of the law. And on the other hand, they have an inclination towards accepting conclusions which are not supported by valid argument structures. Of course, we are aware that all reasoning may eventually be, all reasoning expressed in language may eventually be communicated via some language of logic. However, there appears the question whether our premises of our reasoning are controversial, widely acceptable, or not. A possible new answer to this old debate could be that legal logic in the broad sense, so as a theory of legal justification, is primarily focused on the criteria for rational reconstruction of belief sets of lawyers. So to what extent this belief set should be revised, extended, restricted, and what type of information is relevant for the sake of this process and what not. And what is the scope of application of justificatory rules suggested by different models of justification? So this is in fact a meta-reasoning exercise. We are not favoring or voting against any particular account of justificatory rules at the outset, but we are more interested in a question how they should be applied to solution of particular legal problems. Perhaps there is no overarching theory, perhaps different models are applicable to different types of problems, and the lawyers somehow intuitively know that because of their training. Final insight: any legal justificandum, that is the justified belief, is compatible with infinitely many legal justificantibus, so justificatory theories. So we may reconstruct numerous theories that could justify adoption of a particular belief. And this set of possibilities does not only concern the content of our theory, but also its structure. However, not any legal justificans is able to provide justification for any legal justificandum. And here we can see a certain ordering, stratification between these models. So starting from classical deductive models through non-monotonic, through argumentation schemes, and finally coherence models, we can see that these models provide us with more possibilities. They make certain patterns possible which were not possible or expressible in the previous models. Coherentism is difficult because it's very complex. Also for humans, human lawyers have to work under the pressure of time and limited resources. Therefore, their reasoning is very often very heuristic. The application of artificial intelligence in the field of modeling of legal reasoning may play an important role towards the movement of the application of explicit models of reasoning towards more coherentist thinking, because these theories will have the possibilities to generate the candidate theories automatically. Thank you very much for your attention.
Thank you very much, Michał, for your excellent talk. Very insightful. Let me check if there are questions from the audience. One of them is, wouldn't the defense of a thesis of theoretical indeterminacy of justification bring legal uncertainty at the time of application of the right to a specific case? And another one's asking, taking into account the set of beliefs that are justified by the justifications, do you understand that there is a social acceptance for this theory? Sorry.
Thank you very much. So I think that both questions are excellent. I do not think, though, that theoretical indeterminacy of legal justification implies legal uncertainty. This does not have to be the case. Perhaps it is very visible at the early stage of implementation of legal instruments, where the particular legal act is not associated yet with a lot of judicial decisions and doctrinal elaborations. Given a particular legal text may give rise to the development of very different theories. There is a lot of evidence for that in legal history, where, for instance, the same legal instruments were implemented in different countries, and the doctrines that evolved around and in connection with application of the same wording were different. But that is the fact of life. However, legal cultures in particular jurisdictions very often tend to have a relatively high degree of stability. So these theoretical structures are typically very constrained. So they don't necessarily, this freedom of adoption of particular theoretical structure perhaps is not the most conducive to legal uncertainty. A high degree of legal uncertainty may emerge also within one and the same justificatory structure, only where different lawyers, for instance, accept different results of balancing of values. So we have the same structure, value balancing, for instance, in the sense of Alexei, but the basic preferences adopted by particular groups of lawyers are different. This can, of course, contribute to legal uncertainty. So that would be the answer to the first question. Maybe one follow-up. So in some jurisdictions, actually, this deductive approach towards framing legal reasoning is famously advertised as conducive to legal certainty. This does not have to be the case. Formalism is not always conducive to legal certainty, although it may be. It's quite contingent. This second question concerning social acceptance of certain justificatory rules is, in my opinion, extremely profound, because it, again, calls our attention to the very nature of rules. What kind of entities are they? Are they mental objects, or do they manifest themselves in social practices? Perhaps the mainstream answer nowadays in legal theory is that, in fact, we have here a kind of very complex push-me, pull-you process, where on the one hand, we have established social practices, and on the other hand, we have lawyers who are engaged in the process of critical thinking, and they are subjecting the existing reasoning practices to critical evaluation through asking critical questions such as whether this existing practice is fair, is it conducive to legal certainty, is it economically effective, is it compatible with the current beliefs of the society. But on the other hand, maybe the current beliefs of society are morally reprehensible, and maybe the role of the judge would be to educate the society. So there is this interplay. Between the established practices on the one hand and the critical thinking of lawyers on the other hand. Capturing of these dynamics in computational models is an extremely complex challenge.
Thank you, Michał. I have a question. I like your framework to think about justification and legal justification. The framework admits that the same legal belief may have different justifications. It seems also to it also has a limit. For instance, not everything that can be justified. There are some beliefs that cannot be justified. For instance, torturing a child cannot be justified in the Brazilian legal system. But it seems that there is room also for the justification of opposing beliefs about law, since you talk about incommensurability. So it's an important, in order to explain legal reasoning and law, it seems that it is important for you also to have an account of how to compare justifications. And I would like to hear from you whether you have some ideas on that.
Thank you very much, Juliano. I believe that such comparison is possible to a large extent, provided that I wouldn't dare to state axiomates, because this whole theory is non-foundationistic, in the sense that some beliefs are definitely more stable, some are less stable. Some of them are actually seen as a kinds of axiomates for contemporary legal cultures, as for instance the principle of protection of human dignity. So it is adopted in any civilized legal order. Of course, there may be different opinions as what conducts by the state, for instance, infringe human dignity and which not. However, in this civilized circle, it is not contested that the system of law is based on the principle of protection of human dignity. However, some legal systems, if we still intend to refer to them as legal, are not commensurable with this respect. So some post-totalitarian regimes do not accept this principle, these views cannot be unified in any way, because this is not an actually fundamental principle, but it plays a role very similar to an absolute fundament or axiom. However, if we set the post-totalitarian regimes aside, I believe that this comparison is to a very large extent possible, because the sets of legally relevant values, for instance, accepted in the charters of human rights, are quite comparable in most civilized countries and legal systems.
Thank you very much, Michał. Christoph, do you have any question?
A very quick one. I guess we have time problems, but so that means basically you still have a kind of notion of, let's say, personal inconsistency of a judge or so in your system, but it's more on a meta level. So they're looking over time, looking, on the change of belief sets, eventually on, in the sense of our approach, different logical formalism. So is there still room for consistency in the picture? And I guess so, but it's on a meta level.
Yeah, yes, precisely. So what we are comparing here, to put it in abstract manner, we are not comparing particular objects, but we are rather comparing relational structures.
Yeah, wonderful. I really like that a lot, what you said. It fits very well with my personal view on the challenge we have. It's a complex one, yeah.
Thank you very much. I can also see a lot of common points in the computational work that you are doing in this legal philosophical outlook. So happy to discuss.
So thank you very much. Let us now move for the following speaker. We'll now give the word to Poliana Duquec. It's a joint work by Poliana and Patrícia Sardetto. Patrícia Sardetto is PhD from Federal University of Santa Catarina, and now professor and leader of the Law and Technological Innovation Research Group at the University of Paraná, Campus Londrina. And Poliana Duquec is a lawyer and pursuing a master thesis on the University Católica of Paraná. And she's also a researcher of the Logarithm Institute. So, Poliana, you have the floor now. Thank you very much.
Thank you, Professor. I will share my screen. 1 second. It's full screen or not?
Not yet.
Okay, then do it. Now it's okay?
Yes.
Okay, thank you. So first, I would like to congratulate all the researchers who presented previously. It's a challenge to be here for me, speaking after so many spectacular speeches. So our speech is simpler and more subjective, and it's about the balancing criteria of conflicting ethical principles in artificial intelligence. So the current scenario, 10 years ago, I think the AI started to be a tool that increased its use in society. And in the last 2 years, I think it was the boom of the use of AI, especially because of the pandemic and the need to use more technology and connections between humans. And some examples about the use of artificial intelligence is insurance, credit cards, job selection processes to select CVs, self-driving cars, and an amount of examples that we can notice in society of the using of AI. So there are some conflict of principles in these uses, such as, for example, individual versus collective health, privacy versus security. We can notice about privacy and security that it's very cultural. In the countries that security is prioritized, society accept more giving up their privacy for security, and in places that they prioritize privacy, we can see that the AI and facial recognition systems, they are not used such as in these other countries. So this is the part of Patricia. You can start.
So I try to speak, but my internet connection is really bad today. So I'm sorry. It's okay. Can you hear me?
Yes.
Yes. Okay. So we try in our research to make a comparison between our legal traditional solution when we have conflict of ethical principles, and we try to use the Walter Celeste theory in case of conflict of principles. So in the legal field, when the two principles or more collide, the principle of proportionality is taken into account, while the principles against each other in the face of concrete situation. So we have, according to this theory, we have rules and principles. Both are norms, but there is a difference between both. Rules are definitive commands, so the form of application is subsumption, and when we talk about principles, we have optimization requirements. So something be realized to the greater extent possible given the legal and factual possibilities. Please, next, Poliana. And in legal traditional, most of time in the legal traditional solution, when we have principles, we have optimization requirements, and then the determination of appropriate degree of satisfaction of one principle relative to the requirement of the other principle is brought about balance. So we try to propose this research that we can know that is very, very difficult. But we try to propose that we can use balancing when we have ethical conflict of ethical principles.
Okay, so we have the machine problem because it's different when we talk about the law, the conflict, they can be solved before. So we have a problem and then the judiciary solve the problem, applying balancing the principles. But in machines, they must receive previous comments. So it's hard to let the machine create the problem to solve before, especially because of the responsibility. So the difficulty in working with these ethical conflicts is that we will not always be able to solve them with these rules, with these traditional rules from the law, like hierarchy, chronology, and speciality, especially because it's principles, not rules. So we did research about the AI guidelines that already exist, and we noticed that it's just principles. They don't give a specific answer for specific situations, and we can notice that some principles, they are not able to answer the questions. And these principles started to be debated in 2017, and only in 2019 they started to be they started to write these papers. So this is the problem of that. If we took 2 years to write these guidelines, we have to be faster with these situations, especially because we are using too much AI in our lives, and it's increasing the use. To let it more real, I wrote the COVID case that is an example of ethical conflict, and it was during the fight against COVID, when there was a potential to use AI to save lives and to do the sorting of patients in the hospital. So in case of using AI as a tool to help professionals providing information and directions, it was also necessary to analyze threats to privacy, equality, freedom. So for example, if a man and a woman arrive in the hospital, both have the same age, the same problems, exactly the same problems, how the AI would solve this problem? How would they prioritize a man or a woman? So it's hard, and it's hard even for the law to solve. And especially because in this situation, the AI would have to have the answer beforehand. So it's different from the law system.
So our view, our approach in this research is more a legal approach and a technical approach. The other contributions in this seminar is more technical. Maybe I and Poliana can contribute to the discussion, because we try to propose criteria, 3 criteria to try to solve this problem. We course, we understand that when we talk about machine, artificial intelligence, we need to input objective commands, very clear. And when we bring some ethical conflicts, it's so difficult to input into a machine objective rules, objective commands. So we propose that we can try to put first universal ethical values, then segmented ethical values, because we have guidelines or recommendations, principles in specific fields, such as justice, health, education. So we can have here and the machine another step, segmented ethical values. And we think also very important when universal ethical values and segmented ethical values don't get to solve the conflict. Maybe you can have a technical social governance team opinion, such as rules, previous rules, to help the machine to give a solution in a specific case. Of course, it's very difficult to deal with ethical values. We understand this. Maybe our research is related to the research of Professor Christoph and David. When we talk about hybrid argument or hybrid artificial intelligence. So we are starting to research this issue, and we hope to contribute to discussion. Thank you.
Well, thank you very much. I have here, we have short time for discussion. I will just indicate two questions. There are some questions by the audience. The first one is that the Alex's model is criticizing constitutional law on the basis that the criteria for comparing principles are subjective. So what do you think about that, and how can you handle this problem regarding your research and model? Gabriel Carnaval is asking, based on your research, what are the negative impacts in our society that you see in the creation of AI without an ethical basis? And maybe Alex Knoks is also raised his hand. So please, Alex.
Oh, I just had a clarification question. Thanks for the talk, by the way. So I thought you have this idea that you might use the principle of proportionality in ethics, and I was wondering how would that work exactly. Do you have like a particular case in mind? Because that would help me.
So, can start, Poliana. then
No,
you
Professor,
continue.
Feel free.
Okay.
Feel free to start.
Of course, we know that our criteria, balance criteria, is subjective, and this is very difficult to work with a machine. Maybe this is the difficult for us lawyers and law professors, yeah. So this year I start to study applied artificial intelligence to better understand how work a machine. And of course, we need to understand how kind of input, how kind of commands we have to give to the machine. My concern is about an artificial intelligence just with objective rules, because our life is not objective. We need to be flexible. We need to have room to adapt certain circumstances and situations, and we need to learn how deal with this situation with artificial intelligence. We don't have the solution or the answer. We have many questions, but for us, maybe this criteria to use the proportionality can be a way to study.
Thank you very much, Patricia. We run out of time. We need to move to the next panel, the next talk, which is the final talk by Alex Knoks. And Alex is working at the Department of Computer Science at the University of Luxembourg with the Individual and Collective Reasoning Group. He's going to deliver a talk on second-order reasons in default logic. Thank you very much, Alex, for joining us, and the floor is yours.
Yeah, thanks so much. Can you guys see my screen?
Yes.
Yes.
All right, so yeah, thanks for having me. I've been enjoying the talks. Since I only have about 15 minutes, I'm going to jump right into it. So just to avoid the potential misunderstandings, I should say right away that this project is actually, even though I will be using logic and talking about normative notions, this is not a project that aims to develop a very good logic for normative reasoning. Rather, this is a project that uses logic as a tool to model a certain type of philosophical view, or rather a family of views, right? So at the end of the day, this is a philosophical project, a project in philosophical logic, or perhaps formal ethics. And the view in question is one that allocates a fundamental role to what I call second-order reasons in the analysis of practical reasoning and the domain of practical normativity. And if you want someone who, like, if you want a name for someone who held the view of this sort, then this would be Joseph Raz. He's probably the most, famous proponent of this view. So he's a prominent figure in normative theory and legal theory. And by the way, he passed just a couple weeks back. I had to compress this talk and cut parts of it out. Well, I decided to leave the philosophical ideas, the background philosophical ideas in, at the expense of explaining why the formal framework I'll be proposing is philosophically interesting. So I'm not going to say all that much about that. Hopefully I can make up for it in the Q&A, but let's see. All right, so what are these philosophical ideas that are in the background? So I'm interested in second order normative reasons, and an obvious question is, what is a normative reason? And something like a definition would go roughly like this. A normative reason is a consideration that comes in favor of or against an action. And I should also say that I'm interested in, like in this talk, I'm restricting attention to the practical domain, right? So we're talking about normative reasons in the practical domain. Mark Schroeder helpfully identifies 3 marks of reasons, of normative reasons, namely competition, act orientation, and acting for. Now, the idea behind competition is that reasons are the sort of things, considerations that can, compete against each other, right? So they are going to be the sorts of things that you can weigh against each other. Now, act orientation is the idea that they are things that speak in favor of or against acts, right, or actions. And acting for would be that the idea that these normative reasons are the sorts of things that you can act for, right? You can take certain action. If for something to be a normative reason, you have to be able to act on it. Now, a very popular view in philosophy, standard view, I would say, is that this notion of a normative reason is actually is going to play a crucial role in our understanding of the structure of normativity and in our analysis of normative questions. And it's also going to be related to all various other notions, normative notions. And notice that I say that when I say structure of normativity, I emphasize that it's substantial as opposed to formal. So this is, again, a standard distinction in philosophy. So the idea is that, of course, there are, as soon as you have a set of norms like rules of etiquette, there is a sense in which you're dealing with a formal system, normative system, right? But say rules of etiquette give you only formal normativity that lacks some sort of deeper normative oomph. While there are going to be normative systems, normative domains like like the moral domain, right, that has this like deeper normative oomph. And the idea then is that if we want to make sense of substantively normative domains, then we cannot but talk about reasons. Now, the background idea behind this picture goes back to Ross. So W.D. Ross, his book, The Right and the Good. And the idea is that there's a close tie between the structure of human deliberation and the structure of what makes it the case that you ought to do one thing as opposed to another. And notice how this is a different sort of perspective from utilitarian theory or Kantian deontology. Okay, so people have really, lots of people have taken on board this idea of Ross's. It's also worth saying, worth distinguishing between, so it does again, a staple distinction in philosophy between normative, motivational, and explanatory reasons. So normative reasons are supposed to be different from both motivation and explanatory reasons. So motivational, so someone might be motivated by money, say, right? They act because they want to be rich, but then that doesn't mean that the reason on basis of which they act is a normative reason. Similarly, we might be interested in, say, we might ask, why did the glass break? And answer that, look, the reason why the glass broke is that it was fragile. So again, we use this term reason, but this is not in the same sense, in the sense that philosophers talk about normative reasons. All right, so, but I'm interested in second order normative reasons, and these would be considerations that count in favor of or against taking other considerations to be normative reasons. Okay, and let me give you a couple of cases. So we can talk about positive and negative second order reasons. So positive would be the ones that count for, negative the ones that count against. I'm starting with the letter. And so here's the story. This one comes from Raz. So there is this guy, Colin, and he has to decide whether to send his son to a public or a private school. And there are many reasons that are relevant to the decision he's making, which include the relative quality of education, concerns of cost, and considerations of social justice. And crucially, Colin has also promised his wife to make the decision about their son's education based only on their son's interests, right? So the idea is then that this promise that he's made to his wife is going to exclude some of the first order reasons, and so Colin is not going to be able to base his decision on those. Now, I don't think this is a very famous case. I don't think it's actually the best. I think better cases are the ones where we think about various sorts of decision making that's appropriate to various sorts of formal people performing formal functions like law enforcement officers and search committee members. Okay, so this is a case that seems to involve negative second order reasons. Here's a case that involves, I claim, positive second order reasons. So I call it coin toss. There's two friends, Anne and Bob, and they are kidnapped by the ranged villain. The villain offers them a choice. They can either agree on which one of them gets killed, or if they fail to reach an agreement, then both of them get killed. And what the friends decide to do is to toss a coin. So if the coin lands heads, tails, then Anne steps forward, and then if it lands tails, then if it lands heads, then Bob does. And the coin is tossed and lands heads. And so the reason this case is interesting, right, is that if you think about it, the fact that a coin landed heads has nothing to do with the action of Bob stepping forward. Except, I mean, it wouldn't have anything to do unless there was this agreement that they have made. So now it seems like the fact that the coin has landed heads is actually a normative reason for Bob, to step forward. All right, so those are the background philosophical ideas. I'm interested in these sorts of cases, in the normative structure of these sorts of cases, and how they can be resolved. And now we can turn to modeling cases involving reasons. And I want to start with a simpler case that involves only first order reasons. And I'm going to use this case that everyone uses always, called the drowning child. If you're anything like me, you've seen it about 1,000 times already, but still. So we're imagining a case where you have promised your friend to have a dinner with them, and then you are en route to the restaurant. It takes you past a shallow pond, and then you see there's a child who has fallen into the pond, and it seems like they're going to die unless you save them. Now, the problem is that if you save the child, then you're going to get your clothes wet and muddy, and you're not making it to the dinner on time. Okay. I know it seems obvious that the right thing to do in this case is to save the child. And when philosophers think about it or discuss it, they discuss I guess, these sorts of cases in general. They are typically working with this scales model, right? So the idea is that, look, you have to take there's an ethical decision, you have to figure out what it is that you have to do, and then you have reasons speaking in favor of one action, reasons speaking in favor of another action, and then you have to weigh them. And whichever action is supported by more weighty reasons is going to be the action that you ought to take. Right. So, but this is, I mean, one reason to not be super happy with this is this stays at the level of metaphor. And there is an alternative, I think, which is like the best formal model of the way reasons interact to support actions, which is due to Jeff Horty. And Horty's idea is to use default logic to talk about this stuff. All right, so let's quickly remind ourselves what default logic is. So, the logic comes from the 80s. The idea was to capture common sense reasoning back then. It's a good old AI. And the basic idea behind default logic is to supplement classical logic with a set of default inference rules that capture divisible generalizations. The standard example is birds fly, right? So if the only thing you know about an object is that it is a bird, it seems reasonable to draw the conclusion that it's able to fly. Okay, and so here we will have an instance of this general rule instantiated with Tweety, right? Who would be a specific bird. All right, so the idea is that if I'm able to conclude that Tweety is a bird, then by default I should also be able to conclude that Tweety is able to fly. Now here's a general structure of the way default logic that I'm using works. So we have very good default theories. These are just pairs of elements. The first element is just a set of propositional formulas. also called hard information. And then we have these default rules that allow us to draw more conclusions from the propositional formulas that we're given. There's a logic that lets us do it. It's non-monotonic. This is why I use the snake symbol here. And then what we get from applying logic to these structures is the reasonable conclusions, right? So that's a rough picture of how default logic was supposed to work. Now, what Horty does in his book is he gives it a normative sort of spin and uses it to talk about specifically cases of practical reasoning, right? Reasoning with reasons. Now, the situation here, the default theories that we're going to work with are a little bit different, right? So we still have a set of propositional formulas encoding something like descriptive features of the situation. Then we still have a set of default rules. And now these default rules stand for the reasons relation or the counting relation. And we have a pre-order on these default rules that is supposed to capture or let us represent the relative weights, right? Or the relative weights of the reasons that are represented by the rules. And then we still apply default logic to it, but the conclusions are now interpreted in a different way. So the conclusions that the logic produces are the things that ought to happen, right? So this is the rough idea, right? Okay, so and let's take a look at an example. So this is the Browning child. So we have so P and N here are going to P and N are in the hard information. They stand for the idea that you've made a promise to your friend and that the child has fallen into the pond and needs help. And then we have a constraint that you cannot both meet your friend for lunch for dinner and rescue the child. Okay, and then here we have two default rules that are supposed to represent this counting for a relation, right? So the idea is that P, the fact that you made a promise to your friend, speaks in favor of you actually meeting him, and the fact that the child needs saving speaks in favor of you rescuing the child. And then we have an order, so we say that delta 2 is actually more weighty, has more weight, it's more important than delta 1. Because just saving the child is more important. And then the result is that what you ought to do is you ought to rescue the child. So this is how this logic works. Now, in default logic, this principle is accepted, the principle called chaining, right? So you can go from, if you have two defaults that are arranged in such a way that you can go from A to B and from B to C, you can do that. And Horty also has it in his book. I think it's actually, when it comes to practical reasoning, it shouldn't be good. And the reason is that if you want these default rules to stand for the reasons relation, which is remember, a relation between a consideration and an action, then you should actually not accept chaining. So if there's like one idea that you take away from this presentation, then I'd like this to be the idea that I claim that if you want to use conditional norms to represent what philosophers are talking about when we talk about reasons, then you should not accept chaining. Right? Okay, so this much for these simple cases, cases involving only first-order reasons. Now let's try and see how we can model cases involving second-order reasons, starting with negative second-order reasons or exclusionary reasons. And what we do is we extend our background language which is the language of propositional logic, with rule names, right? Names of default rules, and a designated predicate out that takes rule names as arguments. This lets us build a special type of default rules called exclusionary rules. And this is their general shape. So what makes them special is that you have these out formulas in the consequent, in the conclusion. And then, so this is how you would represent it graphically. The idea is pretty simple, right? So C is a consideration that counts against taking A to be a normative reason for B. Okay? And so this simple idea actually lets you represent, say, the choosing school. Remember, this is the case where Colin promised his wife not to base decision. Well, so the first case I discussed, I don't think I have the time to walk you through this. What I do want to say, though, is a claim that Horty makes in the book. And he says that, look, these exclusionary reasons that Raz talks about in the practical context, in the practical domain, are actually no different from undercutting defeaters in the epistemic domain. And what this boils down to is that, look, whenever you have a negative second order defeating a first order reason, then the normative force of the first order reason gets reduced to nothing, and ceases to be a reason, basically. And I think that's not right. I think I actually disagree here, because this reduces exclusionary reasons to what Raz calls canceling conditions. And Raz definitely doesn't think that canceling conditions and exclusionary reasons are one and the same thing. But I don't have the time to explain this right now. I'm happy to talk about it during the Q&A. Now moving on to positive second order reasons, we use a similar sort of trick. Again, we have a designated predicate in that lets us formulate what I call inclusionary rules. And this is the way this looks. Again, the basic idea is pretty simple. The fact that the consideration D speaks in favor of taking H to be a normative reason for B. Okay, this is how we represent this. And so here's a graph standing for the default theory that captures the coin toss example. So T and H would be the coin landing heads and the coin landing tails. And then A and B is Anne stepping forward and Bob stepping forward. And then D would be expressing this idea that they've agreed to resolve the case in the way that they did. Okay, and it just so happens that H is the case. The coin has landed heads, and you get the results that you would expect intuitively. Okay, so now once you take on board this idea that there can be second order reasons, it's very natural to wonder if there can be third order reasons and even higher order reasons, and the answer and nothing actually stands in the way of also coming up with cases involving such reasons and also capturing them formally. So here I have just a graph representing a situation which is a variation on the choosing school example, where Colin also has a mistress, and then he promises the mistress that he's not going to follow on the promises that he has made to his wife. And then on the right-hand side, we have a case involving a third order positive second order reason. A positive third order reason. All right, so just to note, these high order reasons, third and fourth and so on, they do not actually neatly fall into negative and positive ones. And the easiest way to see that is that when you have a chain of arrows pointing to each other, then it can easily happen that there's a positive arrow pointing to a negative arrow or the other way around. Now, it remains to be seen, though, whether there's going to be any need to talk about reasons of more than, say, 3-4 orders. Right, so, and then this, I think, is my last point. Again, a natural thing to wonder about once you've taken on board this idea that there are second-order reasons, high-order reasons, perhaps, is whether or not these reasons, too, can come into conflict. And so here's the basic idea, right? So we have this guy here saying that A speaks in favor of taking B to be a reason for B to be a normative reason for D, and C speaks against taking B to be a normative reason for D, and it's clear that there's a conflict between them. And then there's a simple technical trick that actually lets you think of conflicts of this sort, think and resolve these conflicts of this sort in the exact same way. Well, I should say in a very similar sort of way to how we do it, how we resolve conflicts between first order reasons, right? We just add a constraint that formulas, in and out formulas that have the same rule name as argument cannot jointly be satisfied. And then the rules representing second order reasons are, then we can put weights on them. And those they help us resolve these conflicts. And I think that's what I wanted to say. Thank you.
Thank you very much, Alex. Let me see, and congratulations for your very interesting approach. Let me see if there are questions by the audience. Are there anyone? Not until now. I think Christoph has a question, yeah?
Yeah, thank you very much. Just a quick technical question. I mean, because you have the second order layer, an immediate question that's triggered to me is whether I can express something like, I'm a reason for that and that, exactly if I'm not a reason for that and that. So if you can construct paradoxical statements in the language. I'm not familiar with the logic yet, but I guess not, but I didn't see why not.
No, so you would have to put additional constraints to avoid. Of course, you can say, you can easily construct a case where you promise to your mistress that you're not going to take the promises of your wife seriously, and you promise to the wife that you can do, and then the thing doesn't work. But
and I guess that's desired and not a problem technically. Yeah.
No, it's not.
Okay.
I'd like to ask also whether you have thought to include in the representation reasons that affect the preference relations between the reasons. For instance, this will be a higher order reason to the effect that may discuss whether some reason should or should not be preferred by the other. So in your model, as I understood, you work with a given set of preference between reasons. This Hartley's model. But I wonder whether the object of higher order reasons could be the very preference relations between reasons.
Yeah, so Hartley actually does it in his book, right? So you can easily have so the theories that I worked with, I used here always have like a fixed pre-order on the rules. But what you can do is you can put that in the language, and then you can have like a rule saying that another rule is to be preferred, one other rule is to be preferred over another, and then you can you can get this reasoning about preferences in the picture. But I guess for this project I was interested mostly in getting Raz's ideas right.
Well, you also have the fact that maybe you have the second order reason to the fact that some reason cannot be, should not be used or is excluded from the picture. For instance, a legal rule, it provides a reason for some action. If there's a moral consideration against that action, the legal reason as an exclusionary one would cancel the effect of the moral. So actually, an exclusionary reason may be an effect of a first order reason. If you have a legal reason against an action, then this is not only a reason against the action, but it's also an exclusionary reason of a moral consideration to the action at stake. So actually, you have, according to Raz theory, that you may have not only the effect of canceling other reasons, but also giving input to another reason for or against the same action.
Yeah, so I think his idea is that once you have, and it's important that this is a legitimate rule, right? So a legitimate law or something. Then it fulfills both of these functions. It points you to the right direction. It tells you what is it that you ought to do, and it also excludes other reasons that might that speak against it, or that support the contrary action.
Yes.
Is that
actually? Yeah. Actually, you would represent that by using different reasons. Yeah, it's also a reason for or against the action. So it's a first order reason, but then you use another reason to represent the exclusionary effect of this first order reason. Yeah.
Yes. So I mean, the way I would do it, I would just have two arrows, right? So there would be an arrow pointing from whatever the reason happens to be to the action, and there would be another arrow pointing to all the all the reasons speaking against it. So that's the way it would do it. Yeah. But I'm a little bit surprised. Are we done?
Yeah, it's as if they were two different reasons in your model.
You would represent them with multiple arrows, and if there were more reasons speaking against the action, then you would have to have like an arrow pointing to each one of those, right? So that for you to get the right result. But then there's nothing. I feel like that's a reasonable sort of way to model the case.
Okay, thank you very much, Alex. This was our last speech. Thank you very much. It's very insightful also, as all the others before. I think that a crucial problem regarding the use and application of artificial intelligence is the fact that artificial intelligence is becoming more and more ubiquitous. So it's applying in many fields of social and economic interactions. And so there is a demand that it's impossible for humans to control, to have a control of these actions regarding its compliance to law or to ethical concerns. So it's important that machines also acquire this ability, as Christoph has said, to move to another layer of consideration about, of reflection about their own actions. And one of the main reflections is whether this action complies or not with the law, or whether this action complies or not with ethical standards. And there's no way, I believe that there is no way of doing that unless we also move to hybrid approaches, combining machine learning with logical representations of legal and ethical reasoning, so that the machine can adapt to changing environments and changing circumstances in different contexts. So I think that our seminar has pointed to different approaches within this direction to try to develop methods which make available and make possible for machines to have a reasoning approach regarding ethical and legal issues. I would like to congratulate again all the speakers for this very entertaining and insightful events with very rich and interesting contributions that show present and research on within this field of knowledge representation and logical representation of legal and ethical reasoning. Before closing our seminar, I would like to thank again Danilo from DIS Advogados for sponsoring our event. And also I would like to thank the organizers, all the team that have worked on this event, and especially Alana Souza, Aline Macoin, Bernardo Saldanha, Fernanda Suriani, João Sérgio Pereira, Igor Burigo, Luísa Magnani, Laura Huescas, Poliana Duque, Ricardo Silveira Ribeiro, and of course, I must mention with a special emphasis Roberto Bornhausen, was the captain of the team in the organization. Thank you very much, Roberto, and thank you to all the team for dedicating your energy and efforts to make this seminar possible. I think it was a very rich and important event to spread what is the present and mainstream research on the application of AI on knowledge and representation of legal and ethical reasoning. So thank you very much. Thank you for all the speakers, and thank you for the audience for the very interesting questions that were proposed and made the discussion also more rich and enlightening. Thank you very much. Roberto, would you like to say some final words?
Professor, thank you for the organization and opportunity. We'd like to take a picture together, all the group of speakers and the organization team. Okay?
Okay, just finally, I would like to ask all the speakers, if possible, to send the presentations, because we are going to let this all the material, the link for the presentations, and in the website of the Logarithm Institute. So let us take the picture.
Everybody turn the camera on, and 3, 2, 1.
Okay.
Oh, once again.